Yes,
I beg to listing for admission. Admission.
You want a matter to be listed in admission? Okay, please give it to the court master. He will have to take adjust the dates. For hearing, no. For hearing, we can't permit, but there are already matters. You can move the registry. If you want for orders, then it can come.
Daily list for orders, item 1.
Notice is served
I'm preparing for this.
for the respondent too, as legal aid counsel. Okay. So you got the paper book?
If I do not get this, but I'm not happy.
Okay, so since paper book is ready, we'll provide it to you. We will fix it for hearing then. Anything you have to say? Okay. Already admitted. It's a criminal appeal. I don't think you would have proceeded without admitting. No, appeal is admitted. Okay.
And Lordship, I is also there, bail petition, 6-7.
Aye. Just a moment.
File our objection.
No, since we are putting it for hearing, we don't find this is a case for grant of bail because there is eyewitnesses to the incident. PW 4, yes. 3 and
4 and 6.
4 and 6, right? All sides are represent, all sides including the counsel, legal aid counsel for respondent 2 are 2 and 3 are represented. Next, for the registry shall serve a copy of the paper book to the learned counsel, legal aid counsel appearing for respondent numbers 2 and 3 within a week. List the matter for hearing. In the week commencing 22/4/2024. Next, as in the IE, as the matter has been listed, as the connected appeal has been listed for hearing, prayer for intermediate shall be considered on the next date. In the event the appeal cannot be taken up for hearing. First of objection, if any, by the learned APP as well as learned counsel, legal aid counsel for respondents 2 and 3 may file objection by them.
Item 2 for orders.
Notice is served. You are appearing. Okay. You have got the paper book. We pass the same orders. 22/4, we fix it to a hearing. No, she has not got it. We fix the same date, 22/4 for hearing. Pardon me?
It may be little upgraded.
No, because again, then there's vacations coming for Bihu.
In more than 2 years, I have been jailed. That is why.
We understand. But she'll need some time to take it and file an objection to the, you have an interlocutory application also. Let her file an objection. I is there?
Any application matter?
No, I. Okay.
Now the main case would be heard.
Yes. Say what is Amy Mohammed for the appellant. Miss and thus learned ABP for the state and Miss D. Papuzeri, learned counsel for the informant, you informant of victim. The informant. Bear with the bracket as number 2. Say one. Please collect the paper book. No need for objection. I objection.
Let the hearing.
Hearing.
On
22.
Okay.
With commencing from then on 20.
We commencing. We commencing. We commencing.
One there.
Yes.
And the 23 or 20 in 22 and 24, I have some outside program.
Okay, then make it 23. Okay.
Obliged.
Item 3.
So Shiva, after some time,
After some time. Okay. Just a moment. Health status report is required.
so Shiva means.
It's okay. Okay. Yeah, director. Health status report to be obtained.
Item 4.
You got the service report?
Service put everything.
No, but you'll have to do it. Last it was 4-3. We'll take it up at 2 o'clock. Try to find out. Give a message to the officer in charge of Golaghat police station at 2.
Item 5.
Is it IFN? There is the query of the last officer that whether respondent is to be brought to this legally it comes to the.
No, because here this is a case where the victim herself was the.
She was the.
376 and 302 otherwise is not required. The informant, the address, is it, here's the address of the. It's somewhere here, nearby, no? So easy to. It's 76 only. 276 plus 28. Oh, 276 one, not required. Three is required.
It would not be required. It would not be required. There's a notification number 17. I just got it. It's not required. So we'll take up the hearing then.
I is pending, my objection is on record.
We'll take up the hearing. So continue. Start.
Lordship, my only prayer here is that, Lordship, because the evidence was convicted on the basis of the medical report. Now the medical.
No, not also medical report, but somebody saw you running out. And
There was-
thereafter, when they came to the house, the girl was found
Lordship,
in disorderly condition and blood was oozing out from her mouth.
Lordship. But all the evidences, Lordship, at the time of the trial, none said that I had been seeing the place of.
FIR discloses your name.
FIR did disclose my name.
So that is the victim saying that, and her statement would be admissible under 32(1).
Lordship, at the same time, Lordship, the medical report which was done, therein there were no signs of any sexual activity was detected. If your Lordship may see the paperwork, Lordship, that is at the medical report, Lordship. That's it, Lordship, page 85, Lordship, it starts from 83. Lordship, therein, Lordship, if your Lordship goes to, yes, Lordship, at page 90, Lordship, of the paperwork, Lordship,
Page 190.
page 90. 90 of the paperwork, Lordship. Therein, the opinion was given. Number one, her age is above 60 years. Number two, evidence of recent sexual intercourse not detected in her person. Evidence of injuries detected on her person as described at the back of the page. Nine.
Just a moment. We, uh, we've discussed the matter, we are not inclined to release on bail. The nature of injuries which are indicative in the postmortem report. And the statement of the victim. Which is recorded along with the sketch map. And taking into consideration that the victim lady was 75 years old.
60 years
60.
perhaps at the time of.
No, I don't know, somewhere it's stated 75 years. That 75 years we'll find in postmortem report, I think. So you see 60, 75, let us say 60. But at that age, we don't find any reason for the such an aged lady to implicate the appellant, accusing him of raping her. Because she is given a graphic statement that she was in the bed, she was fell down and then she was sexually assaulted. The injuries reflected in the postmortem report.
As well as the doctor who had examined her,
Doctors,
11 numbers of injuries.
that's it. The medical examination was done 2 days later on.
13 is
So
the,
recent sexual assault will never be found.
Lordship, the medical postmortem report, it discloses that death was due to syncope as a result of chronic coronary insufficiency. That's a medical term for a heart ailment which happens over the period of time and because of which she had a heart attack. So that is the reason for death.
No, but something must have triggered it. That amount of injury, if somebody has, even I will succumb to heart injuries,
Lordship,
heart failure.
the chronic coronary insufficiency occurs from a longer period, Lordship. There is no
No,
treatment package.
if you can show us a medical dictionary or a medical book which says that women having that sort of ailment,
Yeah, Lordship.
if she is assaulted and raped, will not succumb to the heart ailment. Because when you take a defense, you'll have to also show that.
I'll
And
select
it's a
for-
positive evidence.
Then Lordship, can you give me a date and I'll satisfy with that.
You will not get it. You can take it from me.
because what for the injuries? Can you
Because when I have free time, instead of reading newspapers, I read medical books.
So Lordship, let me make an attempt. Right here.
You will not get it. I can assure you. There will be no textbook in the world which says of the negative. Because negative is something which can't be proved. You can't say a negative. There no textbook will say that once the injury is of this description, one will not die. That is not there in any medical textbook.
But the finding was with regard to a chronic.
That may be there. But the problem is that in the postmortem report, you find those injuries.
injury.
And that lady does not have any, you see, there is nothing on record to show that there was a previous enmity. There was a grudge to falsely implicate you. And not only our court, but we are bolstered by the judgments of the Supreme Court, which says that when a lady is making an allegation, presumption is that he has suffered, otherwise she has no reason to announce to the world that she has been assaulted. She has been assaulted. So therefore, we don't find, we'll fix it for hearing it, but we are not granting bail. Yeah, yeah. Could Mr. M.K. Das, counsel for the applicant.
Legal-
Okay, sorry, legal aid counsel, I think for the appellant. also heard. Mrs. Jahanlal and APP for the state. Next paragraph. This interlocutory application has been filed under section 389. CRPC for suspension of the judgment and sentence dated 28/2022, passed by the learned page 1 session judge Majuli in so and so. Next paragraph. The learned legal aid counsel has strenuously referred to the evidence on record, and it is submitted that the medical evidence does not suggest sexual assault on the victim. And in this regard, he has referred to the radiological examination of the victim as well as her physical examination by the doctor, which is recorded in the medical investigation report. It's an investigation report. What is the name? Medical examination report. Within bracket, Exhibit 2. Post of it may be stated that at the relevant point of time, when the medical was conducted on 3/3/2015, the victim was alive and she had also lost the Ejahar narrating the offense of commission of rape by the applicant on 2/3/2015 at about 11:30 p.m. However, the victim died on 13/3/2015, and her postmortem examination was conducted on 14/3/2015. It is submitted that in the postmortem report, the medical opinion of the cause of death where is that medical opinion of death?
That I have not found the paper book, but I got in the lower court reports.
Saying the
It was
NCR.
provided, but not
Oh,
the paper.
okay. Okay. Opinion of death was, kindly say that.
Lordship, that was due to SYNCOPE, SYNCOPE, as a result of chronic coronary insufficiency, natural death.
Okay. So accordingly, it is submitted that the death, the cause of death cannot be correlated to the alleged incident which had occurred on 2/3/2015. You were in custody since?
Since date of judgment, Lordship, 22/8.
Okay, next, the legal counsel for the applicant is, the legal aid counsel for the applicant has also submitted that the judgment and sentence was passed on 22/8/2022, and since then, the applicant is in judicial custody. He's in custody and carrying out and is serving his sentence. Next paragraph. The learned APP has referred to the objection filed by the state. And it is submitted that this was not a fit case for grant of aid to the applicant or to suspend his sentence. On the ground that the victim herself had lost an hazard. And immediately when the crime was detected, witnesses have deposed to the effect that the victim had informed them of the incident. First of all, moreover, it is submitted that the doctor within bracket PW3 found as many as 11 numbers of injuries on various parts of the body of the victim, which was indicative of sexual assault on the applicant. Next paragraph. It is noted that the Hazard, the victim, who was then alive, Hazard dated 3/3/2015. The victim was then alive, had stated that the applicant had entered her house while she was sleeping by cutting a corner of the wall and gagged her mouth, felled her on the ground, and committed and raped her, as well as assaulted her physically. And when she told him that she will inform the villagers, he had pressed her neck and said that he would kill her and cause injury to her mouth by putting his hand inside her mouth. Full stop. The evidence reveals that the victim had suffered 11 numbers of injuries, including blood, including injuries on her mouth, and immediately after the incident, witnesses saw blood oozing out from her mouth. Post. Next paragraph. The nature of injuries found on the body of the victim are as follows. Page 17, paper book. Next paragraph. At this stage of examining the matter in exercise of jurisdiction under section 389 CRPC, the court is not inclined to examine the evidence and to find out whether it will lead to conviction or not. Full stop. The record indicates two age of the victim. She at some places her age is shown as 60 years, whereas in some documents her age is reflected as 75 years. We don't find any material on record to infer that the victim had any aches to grind against the applicant so as to falsely implicate him of causing injuries and raping her. Next, under such circumstances, the court is not inclined to suspend the sentence imposed on the applicant or to grant him bail at this stage. Accordingly, this application stands dismissed. In the criminal appeal, you say that as the paper book is ready, it is the matter for hearing. Week commencing 29/4/2024.
Hello.
In fact, the chemical examiner's report, they should have made a part of the paper. They did not.
So those come later on. So it is not, may not be kept in sedative in the LCR. So therefore they missed it.
They missed it. Otherwise, it's an
Because
exhibit. only.
normally this expert report, we have not read the judgment very thoroughly. Does it show that as a part of evidence, is this reflected?
It was exhibited
Okay, that they missed it.
because PM report, it's written, conclusion can be given only after saying that.
Correct.
So after that, medical, that report came. And it was
But that
exhibited.
report, we don't just see the IO. That report is not there. Only they are relying on exhibit.
PM report.
Exhibit a postmortem report, which is exhibit 3. It's exhibited by PW12.
The doctor.
Oh, acha. Oh, no, that was done. Just say that this for hearing in terms of order dated 26/2/2024. Only that much.
Actually, gone on here. Yes. Yes. it was taken.
It doesn't form a part of exhibit.
Acha, acha.
It doesn't form a part of exhibit. That is why.
That is why. We have to see the case,
Records. When it comes for hearing, we'll make available to you
records.
the copies. You'll find that at page 80. See, paper book,
Paper book.
page 80. No, not that document, but the reason why it is not there.
Acha. Oh, yes, it's attached with the judgment, yes. Medical report, that is the initial one, EM, FR. It's not exhibit.
Because you see, there's another thing which is, since you asked us to read and your question made us read the evidence. And nobody pointed out when we took up the matter on the last revision that the previous bench could not have taken up the matter. Nobody pointed out. So
Oh, the judgment was biased. Evidence
no,
was
not the
taken.
judgment, but
Evidence
the
was taken.
evidence was recorded by
Acha,
his lordship.
acha. It
That's
makes me
okay.
look just-
That's okay. Well,
Keep your wish.
all right.
Hey, sorry.
Item 6.
yes. Okay, you got it?
Segregated, we have been informed by office, not yet received, okay? Lordship, maybe give us 1 week time.
Objection also you must file. Otherwise,
Lordship. Yes, in the meantime.
there will be delay
Meantime, file objection.
because when he's convicted of offense under OXO,
Lordship.
they are required to give it.
Lordship, in the IA, perhaps there's a order after receipt of FCR and after receipt of service of office, then IA will be considered. So perhaps that.
No, that is okay, but we can't perpetually delay it.
Lordship, in the meantime, we fine.
Okay. Okay, both sides are represented. Ms. S.H. Boral and the APP raised for an is granted 1 week more time to obtain service report through the jurisdictional police station. Service report on the respondent number 2 jurisdictional police station. Next paragraph. The state respondents shall also file their objection to the interlocutory application within 10 days. Within 10 days. List on, after 10 days, give a date for service report on respondent number 2.
First of April. Item 7.
This report is not received.
It's just a minute.
Yeah, regarding silence. First, notice issued on 2 May. Second of March.
No, the problem is that the office sent by. Oh no, it was given it to you.
Moshe, but I have not received from the IO.
You take it up at 2 o'clock, ask them over phone, then we fix a date. At 2 o'clock. Yeah. Please ask someone to call Pragyathishpur police station. Then we'll fix a date. Otherwise, one more date is lost.
Item 8.
Wait, Mr. Lordship. Meet Mr. Lordship. Lordship, as per the last office note, respondent number 2 has left the address. It's a 302 matter.
Exempt service.
Reminder
Mr.
for HCR.
Mr. D.K. Bhattacharya, counsel for the appellant, has referred to the office note dated 14/3/2024, wherein it is recorded that unserved notice in respect of respondent number 2 with postal endorsement within bracket, sorry, inverted comma, addressee left without intimation, inverted comma closed, has been received, which is tied with the record. Next, accordingly, comma, it is submitted that as the appellants were convicted for committing offense under section 302 CRPC, service of notice and respond number 2 is not mandatory. Only one was convicted,
Only one.
applicant. Next, please. The Ms. M. Das, APP, is present. And she also submits that it is not required. The service of notice on in cases of offense under section 302 is not required to be given to the informant or the victim. Oh, sorry, the informant. Next, please. Accordingly, issue of steps, issue of fresh steps on the respondent 2 is exempted. Next para, resultant comma. The name of respondent to or the informant shall be struck off. Next para, the registry shall expedite there's an issue of fresh reminder for the LCR. Next para, list after 4 weeks awaiting receipt of LCR.
Item 9.
Yes.
In this case, Lordship, I have taken receipts on 7/2/2024. But, as I mentioned, Lordship, the office note is not there regarding the service of computer.
No, it's there. It has been given to the APP. This A, I'm counsel for the appellant. This and thus landed APP shall take note of shall take note of the office note dated 16/2/2024, indicating that copy of notice was furnished to the learner APP for service on respondent 2. Accordingly, the notice was received by the Office of the Public Prosecutor Assam on 17/2/2024. First of the learner APP shall inform the court about the as to whether notice was served on the respondent 2 and shall obtain a service report from the jurisdictional police station. This is Kokrajhar Police Station. Just check out
Bogriwari Police.
Bogriwari. Okay, so the jurisdiction Bogriwari Police Station. Bagribari. We'll fix it after a week, next
Yeah.
Monday.
Next week.
They have not filed their objection.
In the
yet.
meantime, we'll have.
Okay, in the meantime, objection shall also be filed in the matter. List on 1/4/2024. You're giving you 10 days time.
Apply.
Item 10.
Lordship, in this matter, I was supposed to have my objections. Should I bring for 2 weeks for the time? Lordship? I'm bringing for 2 weeks for the time.
2 weeks time. But by then you will be very busy. Why? We expect you to be very busy in 2 weeks time.
No, that is not concerning. Lordship.
No, but you'll have to advise so many people. We expect you to be busy.
No, that is not my.
No, people will not leave you. I know you will not solicit it, but people will not leave you. So after 2 weeks, you are not doing anything.
I'll be very much here, Lordship.
But Mr. Burman will be offended if we give you so much time here. Okay, but we'll give him 2 weeks time. Okay. Mr. N. Burman, counsel for the appellant. Next, Mr. R.K.D. Chaudhary, Leonard, DSGI. Prays for and is granted 2 weeks for the time to file objection.
I'm appearing for respondent to Lordship.
Respond number 2, no, 2. Miss as under APP is present for respondent numbers 1 and 3. List on, give a date after 2 weeks.
Third of April.
Press.
Item 11.
Yes. Give the part 1 file. Oh, it is here. Yeah, it's here. Yeah, yes, yes. So we'll the service report is not there, so we appointed amicus curiae, I think. Because they will not be able to solve, even the Jarikara could not find, and postal steps has also been returned. Mr. Dhar, we find you here, can we appoint you as amicus curiae in the matter? This is High Court report. The community is sent. But Mr. F. Hawk Leonard, counsel for the applicant, dash appellant. Sorry, applicant, only applicant. And Miss S.H. Bora Leonard, APP for the state. Next paragraph. Seen the process service report dated 17/2/2024, indicating that notice could not be served on the respondent number 2 as they were not known at the place of residence, at the address given. Full stop. The steps issued by registered post on respondent number 2 has also been returned with postal remark, inverted commas, insufficient address, full stop, RTS, inverted comma closed. Next paragraph. Therefore, as notice could not be served on the respondent number 2 by process issued on both, process issued both by registered post as well as by usual process, comma. The court is inclined to appoint Mr. A. Dhar Lanet, legal aid counsel, to represent the interest of respondent number 2. Next paragraph. Mr. Dhar, this is section 5 application. There's a delay of 28 days. We condone that. We record your. Stop. Next paragraph. By this application filed under section 5 of the Limitation Act, comma, the applicant has prayed for condoning the delay of 28 days beyond the period of limitation in filing the connected appeal. Stop. Having heard the learned counsel for the applicant, comma, learned APP as well as learned legal aid counsel for respondent number 2, comma, the court is of the considered opinion that the explanation tendered by the applicant constitutes good and sufficient reason for not being able to file the connected appeal on time. So accordingly, this application stands allowed. And the delay of 28 days in filing the connected appeal stands condoned. Next paragraph. The registry shall now list the connected appeal. Sorry. Shall register the connected appeal and list the same in the admission column. Please give a copy to him. He'll require it. Because he has to report to the court. Next paragraph. The registry shall reflect the name of Mr. A. Dhar as legal aid counsel while listing the connected appeal. You said something?
389 application is here. 389 application is there.
Pardon me?
There's a IL for pay.
IL for pay.
Today? You want us to take it today? No, we can't.
Next pay not.
Unless the appeal comes, we can't take it up. But we can dismiss it if you want.
I am not representing the council. I'm not representing.
Amicus curiae. Okay, amicus curiae, not legal aid counsel. Okay. No, there's a difference. There's a difference why we write, because for this matter of amicus curiae and the legal aid counsel, I did not have clarity. Therefore, I called the what do you call, State Legal Services Authority secretary. She told us that a legal aid counsel will get expenses incurred. Say like small things like typing or so which you spent is normally reimbursed. but that reimbursement does not go to amicus curiae. So that's the only reason why I started the using of word legal aid counsel. But amicus, okay.
Item 12,
So Mr. Hockey did not say tell us. We take up and dismiss it or we, no, okay. No, because if we do, unless you tell us, we can't do anything. We, we could not close the matter. Okay.
Yeah, please.
Yes.
One I is there, 198 of 74. Here was report was also regarding whether the treatment is required by the.
Okay, yes, 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 yes.
To that effect, also, we received the medical.
Yeah, one, please.
Phase 3 will be relevant also. Please table. Yes, table. It will go, yes, so yes, sir.
I think let's do this take interim date and game, which is previous one. He was also going.
What is the term we use, furlong or that interim bail? Interim suspension, what is the term called? Legal, what is the legal term? No, parole is the government. That can be given by the government. One excludes counting of sentence. One is inclusive of sentence.
Once the course of get some surgery, the idea actually needs surgery.
Yes.
Provisional basis.
Yes, probably we grant him an interim bail for a period of 1 month
Medical.
on medical ground. And then he'll report back to the jail. He's in which jail? District Jail Tarang. There's multiple ailments.
This hemodynamically is stable. Hemodynamically he's stable, but he's critically ill, I suppose.
That's the impression we are gathering.
Correction, Lordship. Is it called provisional bail, Lordship? Is it called provisional bail? Lordship?
Provisional bail. That's why we are asking you.
Yes.
Tom. You see?
নিজের মানে
This is another issue you should take up. My list is endless. You add one more. About some training to to your entire team on essential medical terms. Because unless you understand the certain medical terms, you may be taken, you may not be able to read this correctly. You see in this Annexure 10 is a imaging report. There are two typing errors when it comes to name of the disease. Two typing error. One typing error leads to a different disease altogether. This page 10. Mild calcitosis. This is normally related to childbirth. Spelling, if it is separate, if it is spelled CALI, then it leads to a different disease altogether. Then in this report, you were reading that hemodynamically stable. You are aware what is this? Hemodynamically stable.
Blood pressure, as per Google shares lordship,
Yeah.
when blood pressure in heart is still.
Heart is functioning. So he doesn't have heart problem. He has a problem with his kidney and gallbladder. A calculi is being formed in the gallbladder, and then in the kidney he has calculi. So therefore, nothing to do with heart. So this is an unnecessary word used in the medical
Yes.
report. Hemodynamically stable, if he doesn't have a heart problem or pressure problem, he will be dynamically stable.
Still he is critical.
He needs surgery for a different ailment, not for heart problems. But it is good you searched. At least you are aware of what is there. So what is the term you said? It is
Provisional.
provisional bail.
Subject to correction.
No, we don't know.
Usual term interim.
Mr. M. Amit, and counsel for the applicant. Also heard Mr. S.H. Baral and APP for the state. Next one. This interlocutory application has been filed by the applicant with a prayer for directing the jail authorities to provide the necessary medical treatment, public surgery to the applicant number one, namely Hasimuddin, Hasimuddin, aged 68 years, who is undergoing sentence pursuant to judgment and sentence passed on 25/4/2023 by the learned Session Judge Darang, Mangalday, in Sessions Case number 9 within bracket capital DM bracket closed oblique 2018, thereby convicting him for commission of offense under section 302 oblique 34 IPC and sentencing him to suffer rigorous imprisonment for life and to pay fine of rupees 5,000 with default stipulation.
The last part. Or to grant him bail, that's where I look, huh? Or granting bail, last part.
Or to granting bail. What about treatment first? What about treatment if he is requiring surgery? Why it is not being provided?
Dr. Esper, which was Lordship, he was sent for further treatment under urology department. That is on 23/11/2023. Phase 3 Lordship of the report. And thereafter, now although he's stable.
But then we'll have to direct the hospital authorities to give us a report. Let a medical team examine him for the purpose of surgery.
Yes, so that report will be required.
We'll ask for that.
Whether you want to do request, no?
Please don't write that. This is an application. Just say but so and so. The next para, you omit all the others. Huh? Then you please say so pursuant to the order dated 11/3/2024 passed by this court, the learned APP has submitted a report by the Superintendent of Police, Darang, Mangalday, in respect of convict AC oblique 7472 Hasimuddin, Hasimuddin. Full stop. The medical report prepared by the medical and health officer, District Jail Darang, Mangalday, is as follows. This is separate. This one. I'm putting a pink flag. Full stop. In view of the medical condition of the applicant as reflected herein before, the Superintendent of District Jail, Mangalday, shall make arrangements to send the applicant to Guwahati Medical College and Hospital full stop. And not full stop, comma, so as to enable the hospital authorities to constitute a medical board for examining the applicant and to take a decision as to whether the applicant requires necessary surgery. Next paragraph. What is the what is the procedure to have the medical board constituted?
Lordship will direct the superintendent of the jail to report to the
Concerned department.
of the medical, whatever medical.
They will constitute and then he will be bought.
Then they will.
Okay, next paragraph. The court is inclined to provide that the superintendent of district jail Darang, Mangalday shall intimate to the superintendent of the Guwahati Medical College and Hospital this order so as to enable the authorities in the Guwahati Medical College and Hospital to constitute a medical board and inform the superintendent of district jail Mangalday about the date and time when to bring the applicant for examination. Full stop. On the appointed date and time, the superintendent of district jail Dharam shall, Mangalday shall make arrangements to produce the applicant before the medical board for his examination. And upon such examination, a report shall be provided to the superintendent of police. No, sorry, superintendent of district jail Dharam Mangalday for onward transmission of a copy thereof to this court through the Office of the Public Prosecutor Assam at Guwahati High Court. Full stop. We are listing this matter on 5th
5th of April.
5th of April. You are getting sufficient time to do this. The next part, the superintendent of district jail Dharang Mangalday shall ensure that the report is furnished to the London to the Office of the Public Prosecutor Assam within 4/4/2023. It's 24, sorry, 4/4/2024. Next by list on 5/4/2024.
Can it be on 8th?
8th. Because we will be too close to vacations.
Then Lordship, right.
You have any difficulties?
Lordship, thing is that today is 18 Lordship.
Yes. So 18 means you are getting 3 weeks time.
Yes. That will.
Otherwise, we'll be too close to
Holiday.
holidays.
The concerned department will be Lordship, Surgery and Urology Department. Surgery and Urology Department. That has.
No, we are not saying anything.
Yes.
They will take a decision
Lordship,
because we are not restricting to this.
yes.
He may have many other. So just correct the language. You see, he will send the medical for the order along with all medical documents. Along with copies of all medical documents. Along with copies of all medical documents.
A copy of the order.
Okay. Copy. The court master will provide the London APP copy of the order for onward transmission to the Superintendent of District Jail, Darang Magalay.
Ordinance.
Item 13.
Come for the first time. Okay, continuation of delay. Mr. P. Bora, counsel for the applicant. You have how many days? 31 days beyond the period of validation. Steps on respondent two by registered post with AD as well as by usual process to be routed through the jurisdictional magistrate. Reasonable date. After 4 weeks, make it 5 weeks.
Twenty-fourth of April. Supplementary item 21.
May please, your lordship.
Yes,
Today I hear some
yes,
maybe kindly have a look at please double one.
yes. 3073 23 302.
Kindly have a look at para 46. 46, 47 and 48.
Pardon me? You wanted us to read which page?
Lordship, page 119, interim judgment, para 46, 47 and 48.
119.
Of the paper book.
Yes,
May I
but you see, before that, here is a case where there's a the deceased was shot. And there's one witness, the number I will not be able to recollect. He has stated that he was also there and he was also injured.
only vague allegation against him, present Lordship accident. Lordship kindly have a look at evidence of PW 5. He stated only two person named, one Alauddin and another person, Lordship, not.
No, but no, one witness said specifically that he suffered either 1 or 2 bullet injuries, including one in the navel. So why will he give a false evidence?
But that is true, but my name was, I'm not specifically, that is my. In the para 46, 47 and 48, learned court below acquitted other Lordship accused person on the same reasoning, Lordship presented appellant. Lordship kindly have a evidence or look at the evidence of PW 5. Clearly stated, evidence of PW five.
5, yes.
May I read, Lordship? I had seen accused Alauddin and Bijoy Amse amongst the crowd who were firing gunshot at us. Specifically named two person, Lordship. Lordship, that is,
This is submitted.
page 25 of the paper.
What would be the implication of section 149 here?
Lordship,
Because he says that these two were there amongst the crowd.
they only, he has seen, it is his clear statement, Lordship. Now question come whether when 49 will come. Lordship, it is the case of the prosecution that they are in possession of the land. But according to PW 11, it is a first land and it was donated by the Lordship Khassia people. Lordship also, that also kindly have a look. That is at page 48, Lordship.
The name of the appellant is Yuxiang Khasia.
Their allegation is there, these three appellants, these three convict and other. But specific statement was given by only PW 5. None else. And they indicated only 2% from the crowd.
But still, we are not inclined to grant bail. You can, since the paper book is ready, we'll hear it. You see, there's two things. Number one, in the cross-examination, except for PW six, where two names were suggested that these people were not there. There's a suggestion with regard to two accused persons. But insofar as Yu Suchian is concerned, there's not even a suggestion that he was not there. PW 5, 6, to them, so this suggestion is not there. Then these two people are also victims. They say that they suffered, one said that he suffered an injury in the face, gunshot injury. One says that he was shot in the navel and in the arms. So two gunshot injuries. Then all the witnesses consistently say, including 5 and 6, that 6 said, I think, that 40 people armed with guns were attacking them. That means it includes this UC Chang also. If you come to the evidence of PW8, PW8 specifically names him, and he also says that he is also an injured person. Therefore, you'll have to tell us he could identify in this crowd only 4 people. Of 4 people, this UC Chang is there. Now, please tell us one good reason why somebody will be getting a shot at. He also received a bullet injury. He will receive a bullet injury by A and he will name Yu Suchian. Why?
Lordship, that is true, but allegation is bad. My first submission, Lordship, on the same reason is Lordship, Lanet, Court below, appointed 4 other persons.
No, we see at this stage on 389, we are merely examining whether a possible case is there. And number 2, whether on that basis bail can be granted. We are not examining the evidence.
Other, it is their case that they are in possession of the land. But.
No, that is a, you see, we are not examining whose land it is. You see, it may be land of A. And A gives a, what you call, what is the term? He takes private defense.
It is Dickon Amse Lordship is not before your Lordship. He expired during pendency of the Lordship trial Lordship. He was attacked by the complainant side. His house was burned, and in retaliation, this person, Dickon Amse, fired. He also surrendered, and that is Lordship. Kindly have a look at the evidence of PW. That is my
PW
11. Lordship.
11.
Lordship, kindly have a look at page 44. There are 7. Lordship.
Page number
Lordship, it is started from page 43. of the paper,
43.
and it is para 7.
Okay, just give us 2 minutes break. We'll come back again.
Lordship,
Take a short break and come back.
একদম ইলাচিও পাবি তই আগতে ইলাচিৰ পৰা তাতে থাকি Provided that the central chamber to any Congress exist as an opportunity of showing for the এইটা একটা নতুন এটা তো হেভি হবো না এটা হবো মান ক্ষেত্র এখানে দিছে কিন্তু মিডিলও হল যায় you reminded us your book will give notice no and big no so is the judgment of law no the law এটাও বলছে এটাও বলছে কি wrong in it for greater justice very notice the photo the power to the that's a clue backing it up. And otherwise, you remove it and equity people will be motivated.
U11 who is the IO Lordship, kindly have a look at para 7, para 14, and the Lordship, cross parts Lordship, para 10, page 50. Lordship, kindly first come to page 50, para 10.
55-0.
50.
Yes.
It is the statement to the Lordship, your Lordship, in the charge sheet being submitted in the instant case, it is stated that on seeing accused Diken Amche,
No, I think we are on different page. You are reading which page?
Lordship, it is cross part Lordship base,
Page.
page 50.
50 first word is para 14. Exhibit A, PW 11.
Or Lordship, then your Lordship, it is, in my copy, Lordship, it is page 50, Lordship, page 49.
Page 49. Yes, in the charge sheet, yes.
In the charge sheet, being submitted in the instant case, it is stated that on seeing accused Diken Amche, the other charge sheeted accused person raised protest. Complainant and his party became violent and set fire to a hut of accused Diken Amche, who then, finding no other alternative for his self-defense, started gunfire from his issued gun to the fellow of the complainant and his party, and others, namely Rehanuddin, Abdul Salam, Jainaluddin. This is the statement of the IO. Lordship, why this a group of people 25 in number, why they are at the place of occurrence on that particular day, where even they failed to establish their possession. It is a Khasland, Lordship. Kindly have a look at para, Lordship. Para 3, page 48. The place of occurrence is a Khashia people known as Khashia Punji at Elakargul. Then Lordship, kindly have a look at page 44 and Lordship 45.
Forty-five.
Lord-
Yes.
Lordship, para 15, kindly have a look at. It was reported that during investigation, para 14, I sought report from SDC Padalpur regarding the ownership over the disputed land, place of occurrence, and accordingly collected the report. It was reported that the said land is a first land. So prosecution at first, Lordship, miserably failed to prove their possession, and then Lordship, in Lordship, page 48, para 3, Lordship, it is clearly stated that it is a, it was possessed by the Lordship, is accused side. And I also stated that Diken Amche fired for his self-defense. And the Lordship, another thing, Lordship, Larnet Court below rejected this plea on the ground. Lordship, kindly have a look at para 38 of the imperial judgment at 117.
You see, very difficult still to consider the prayer for bail. Number one, you have not been able to demonstrate that you did not exceed the right of private defense.
Lordship, it is not for me, Lordship. It is
No,
the
no, no.
accused number, Lordship, Diken
No,
Amche.
no, we don't
He-
know. You see, one of the witnesses said, that's why we said, today we have not read the evidence in full. It's just part of it, what you call a general glimpse of what is there.
Not-
Number one, we have told you that one of the witnesses, PW6 perhaps, he says that he identified 4 people, which includes you. Now, if you kindly look at 313 examination. In 313 examination, you take a plea of denial. And in the last question, you say that you are not at the place of occurrence, you are at home. Now, for that, you don't lead, you see, you take a plea of alibi. For the purpose of plea of alibi, you have not given any further evidence. Therefore, in view of the lack of cross-examination of PW6 on your presence, you see, how can we
Lordship,
take?
regarding the item private defense, I will satisfy your lordship. Today I am not ready, lordship. another
No, no,
lordship,
no.
kindly
You see,
await
because that is
another
something which will be
date and
determined at the appeal, not at the stage of suspension or
Lordship,
sentence.
That is true, but against him, lordship, my humble submission, PW 5 clearly stated it is Alauddin and the lordship Vijay Amse. My name was not there. He has seen that
No,
these
you see,
two
you
persons.
see, kindly tell us how many bullet injuries are there?
That may be, lordship, that.
How many
that can be
people?
done.
No, no, I'm asking how many bullet injuries are there in various injured persons or deceased?
This is lordship.
How many?
But
So,
medical
no, no.
officer was also not
In,
examined.
in a totality of the bullets fired, how many persons, including the deceased, how many bullet injuries are there? There's more than 6?
But that.
Is
that
more
was
than
not
6?
clearly
No,
proved,
no,
lordship.
no. Is more than 6 bullet injuries? Now, you see, I have my limitations in criminal side. You are aware of it. But then I'm asking a question. These 2 people shot. That means there are more than 2 arms, more than 1 arm, sorry. There are more than 1 arms. And injuries are more than 6, therefore we can definitely say that there is more than 1 firearms. What is the nature of firearms? You don't give the evidence.
Lordship, that is failed, prosecution side failed. Doctor was not
No,
examined.
that's okay.
and
But you
all
see,
the
you are
injuries were
taking a plea of right of private defense. You say that it is only these 2 people who gave the shot. Therefore, and one witness says that there were 40 people and everybody was armed with guns and everybody was shooting everywhere. Correct. Now, we take it that this was an exaggeration. 40 people armed with guns and shooting, it's an exaggeration. But you have taken a plea of what you call alibi. One witness, you see, we are not examining the evidence for the purpose of appeal hearing. We are examining the depositions with limited, what you call, for the limited purpose of seeing whether 389 can be exercised. Correct. Therefore, when one witness says that you were there and you take a plea of alibi, and there's no cross-examination, worthwhile cross-examination, do disprove that you were there. Now your plea of alibi fails. Under that circumstance, how should we grant you suspension of sentence?
Lordship, that my submission, lordship, whether 149 will come and whether right of private defense is established, lordship, give me, lordship, give me another date, lordship, I satisfy on this point. Okay.
How much time?
Uh,
1 week. Okay.
In fact, there are other 2 appeals filed by the other 2 convicts. Those are not tagged together and paper book is also not only one. The other 2 will also be included here, can be included here.
We'll list it after 1 week, all these appeals together, connected appeals.
Vijay Amse and Alauddin, they have also filed their appeal and.
You have a number, their number?
No, I don't have the number. I can give the number. I can find it out from the website also, yes. I can give the number.
After
in
some
5
time?
minutes time.
After some time?
Not.
Okay. Both sides are represented on the case made by Mr. L.R. Mazumdar, counsel for the appellant, public applicant. Matter stands adjourned today. List after a week, along with connected criminal appeal number. That number she will give you after some time.
Yes.
Criminal number, so and so.
but registering and item to provide the fund.
Pardon me,
Registering it to provide the fund. In this case, the fund.
you have not received?
I have received, I have got it.
Okay, next para. In the meanwhile, the registry shall provide the copy of paperwork to the learned counsel for the applicant. Dash appellant.
Vijay Amse number I got, this is criminal appeal 355 of 23. And the other is Alauddin. The other criminal appeal, your lordship, that is 374 of 23. Okay? 374.
Mhm.
There wasn't it?
Yes, item
The
three.
other two numbers I've given.
Yes, yes.
Typing item 3.
In the earlier occasion, the lordship has directed us to take the medical report from the concerned chair authority. Lordship has submitted the same to the court master. Lordship.
Yes. Surgical department. Medication. This is I. This is I. So I use. We just wait for some time for Mr. Hassan to come. Because he's taking medication regularly now. Just give him.
Item 14 with 15 for hearing.
But in this case, Lordship proposed to initiate a suo motu criminal appeal against the informant in our case, Lordship. What had happened, Lordship? By a common judgment, Lordship, two trials were disposed of by a common judgment. And Lordship, this by an order of 15/6/2023, the coordinate bench of this court has held that this is against the law laid down by the apex court, Lordship. So he proposed that the matter should be remanded back. So, but before remanding remanding back the matter, Lordship has indicated that we would like to hear from the persons who were earlier acquitted by the common judgment, so that no prejudice is caused to them. So notice were served, but they did not appear. So in such circumstances, Lordship on last day, Lordship proposed that a suo motu criminal appeal be initiated against those acquitted persons.
That the file. Vijay? Yes.
One number two. Oh. People wanna 347 I can go back. Person in 131, no. Executed person in 347? Manita Hamid. Mitigating activity. No. And what do we- এইটা তুমি নাও। Equated person in 131 Alif Mia, এইকেইটা কোন? Last paper 131. Alif Mia, Alif Mia, Shahjahan, নতুন তুমি। এইটা তুমি। তোমাদের নাম আছে।
Mr. Ganguly, s- small sound is higher pitch. If we are correctly appreciating your submission, you are trying to say that on the last occasion, we expressed our mind that we should either file a take up a suo motu appeal against Equitel and then issue a notice, or to have them impleaded here and then issue a notice. Yes. Yes, what are you trying to say?
Impleading here will not be again possible. Because, no, the requirement is that they should be put to notice only to let them know that the matter will be remanded. Because remand will be the ultimate result. The only problem is that they should not get prejudiced, they should not be taken for surprise that notices are issued from the lower court. So that is why Lordship has issued notices to them. So what
No,
I would
we are, you
suggest
see, we
is-
are also concerned with one issue. You see, these three acquitted persons are not parties in this appeal.
cannot be also
Now,
there.
if I put myself there, I forget for the time being that I have some legal knowledge. I am a rustic villager without legal knowledge, and I receive a notice in connection with criminal, the two criminal appeals. There's three criminal appeals, 82, 85, to two appeals. Correct, we get notice. Now, what should I think? That I have received a notice, I am not a party, but wants me to be present. Now, if
But
I'm not, if,
in connection with sessions case number, that is how the notice will go. But otherwise, suo motu registering an appeal against them and sending notice, because the ultimate effect is only to remand the case. That will be again a new procedure that will be established. New appeal, then notice, and appeal Lordship will not hear. Lordship will ultimately remand.
not
And in
as,
fact,
it's not as simple as
Huh.
you're projecting. You see, an acquitted person, why will he appear?
Yes, definitely. Technically, yes. But Lordship can take a clue from section 386 when somebody comes for enhancement of the sentence. Then I mean, it has to be heard, the acquitted people, the accused person, of course, enhancement of sentence, they will be parties, I think. Lordship can see 386 last, 386C. Then they will be parties there. Provided that a sentence shall not be enhanced unless the accused had an opportunity of showing cause against such enhancement. Here they will show something that matter may not be remanded or matter may be remanded. That is what they are called for.
You see, same question was posed on the last date also. Now, in this, we take a case where there are two accused persons. One is convicted, one is acquitted. Now we remand the matter. In remanding, what do? We'll have to set aside the earlier order.
Yes.
Now, is it possible for us to set aside an order of an acquittal
Without there being any challenge.
without there being any challenge? That is number one. And number two, when we are looking at an appeal against acquittal, then the parameters are different From-
Parameters are different.
from
Does
considering an appeal against conviction.
Second.
Parameters are different. So therefore, you see, technically, we're just thinking aloud, whether technically it would be appropriate for the court to restore, to register a suo motu appeal. Then what happens is that we are exercising jurisdiction vested in the court in law to issue a notice. If you can show us that this provision and the CRPC permits issuance of notice on a third party, because after acquittal, the status of the acquitted accused would be what? There's no appeal against them, so they are technically third parties. So can we hear an appeal by issuing a notice on a third party, and whether a third party will have a right to address us
Without them.
without being implemented? Because you see, the concept of, even if we borrow the concept of intervener from CPC, in criminal appeal, there can't be an intervener like that.
No provision as such.
There's no provision in the CRPC. That is why last time we were thinking aloud and then adjourned this matter, thinking that on service of notice, they will perhaps
Last time I
come.
was not there. But one thing, in fact, the notices was not required because admittedly the judgment is wrong. A matter has to be remanded, so perhaps
No, no, no.
remanding would be sufficient.
That's the question. Has to be remanded, we all know that. This court has given a judgment, has to be remanded. Now, what is the modality?
Simple remand would have been sufficient.
For remand, we have to, it's mandated to set aside the judgment. Otherwise, you see, let me think of myself. I am a second class magistrate. My order, my judgment has not been set aside. Matter has been remanded. What would I do?
No, judgment has to be set aside. They
So,
will have to hear
judgment of acquittal without hearing them, can it be set aside without an appeal being registered? That is the moot question. That is why this endeavor of understanding, we took 3 days today is the third day we are hearing this matter. Only on the simple question of how effectively to pass an order.
Because the judgment is void ab initio.
Given water to
The judgment is, in my humble submission, is void ab initio. So, in fact, setting aside the judgment of acquittal as well as conviction will not be that difficult, I think, because it's non-est.
No, passing of orders is okay. we know our powers, we know how to, perhaps we think we know how to pass an order. Correct? So, there is no difficulty in that. The question we are asking you again, can we do it?
Since it is none, since it is illegal, the judgment.
You know, that
not-
is why it's a very interesting episode in Ramayana. I have told this story many times here. I have repeated it many times. I'll repeat it again. You know, Lord Hanuman had the power to jump to Lanka. But yet there is a Hanuman Shruti before he actually jumped. You know the reason why? You have heard stories that he wanted to jump and eat the sun.
Yes, that I've heard.
So therefore, his powers were restricted by the gods, saying that once he is reminded of his powers, he can exercise that power. And therefore, when in the second time, when he had to jump to Lanka, there was a Shruti done, he was reminded of his powers, and then with that, he retrieved his power to do what he did. Was only after that. So we are asking the same question. We have the power, that is okay, but please invoke it. Try to show us that this is how it to be done.
My humble submission, since the judgment is illegal, any consequential order.
In criminal, you can't have that concept of void initio judgment. It has to be set aside.
Yes, it has to be said.
If it is wrong, void ab initio, still it has to be declared ab initio and then sent back. But can we do it without hearing them? Again, same question, I'm repeating it again. Can we do it? We don't
Gaurav
find.
Bhatia, before your lordship, he is there for all the other, in one of the
No, it's not for acquitted. Otherwise, we would not have spent time. You are appealing for,
131. 347, the informants are the acquitted parties. So informant, she is appearing, she can appear for the relatives also. I mean,
Let
she
her
have to
take
take
instruction.
instruction.
Let her take
Under
instruction.
instruction.
They have not instructed.
I know that. That's why you are asking. Now, we'll be issuing notice on, in this accused on whom we are issuing a notice is in sessions case number 347.
347, he is 131 acquitted people. He is acquitted people, convicted people of 131, acquitted accused people. 131 or no? Yes. These are cross cases, so informant side will be the acquitted person in 347.
Yes,
One in.
you admit that you are the three people. Three acquitted persons you are appearing.
Five. Five.
Five.
He is representing the acquitted persons in our case.
Yes. Sections 1. Just finds. Consider the paper book page 164.
Paper book 164. Yes, 164. The acquitted persons are
Acquitted persons are serial number 3
in 131.
in 131.
Serial number 3,
8,
8,
9,
9,
11,
11,
and 13.
13.
Appearing for them. But in 347, nobody has appeared. These are the accused persons who have been acquitted.
All four have been acquitted.
All 4 have been.
So that is why we are issuing notice only on 347. This court had passed an order issuing notice on 347.
She is informant. In a cross case of
In 347, she is for informant. So she is again not the accused persons. She may be a relative, but still She is not for the accused.
Take instruction.
Definitely, because otherwise she'll have filed a wakalatnama. This is something we can't. We can't, what you call, pass orders judicially to ask her to appear. But that would be violative of the Advocates Act, where soliciting is prohibited.
Notice I was in it. I notice I was in it. 18 side, ale? নাই হোৱা। তেতিয়া আমি পুলিচ থ্ৰু দি নোটিচ পাম।
সেইটোৱে better। এতিয়া আহিব।
এইটো টেকনিকেলি হয়, সিহঁতে পাৰ্টিয়ে নহয়, সিহঁতে কি কব, এইটো হয়, আহকচোন। নোটিচ দিয়ে দৰকাৰ নহয়, ইমান কৰি দিব লাগিছে। তলপতে নোটিচ দি দিব। দুজনী কেছ ভিতৰত আছে ন? সেইটো কৈ দিয়া, এটলিষ্ট নোটিচ চাই হৈছে। ডেফিনেটলি সিহঁতে পাৰ্টি নহয়, নাহিবও পাৰে। সুমতো appeal register কৰা against the acquitted person. Procedure নকৰে, remand কৰিব। Impleading we have to implead কৰাৰ কোনো কথা নাই, performer respondent কৰি। Or I can serve the notice.
We'll inform you at 2 o'clock. Let us deliberate and take
Or
a
I
call.
can serve the notice to the police officers to these respondent to these.
So that attempt was made.
That attempt was. Notice was already issued. And
Notice
I'm
was
sure
issued.
served also, but they, of course, they are not parties, why will they come? But then court's order.
No, you put yourself in that place. You're an acquitted accused, let us say, for a time being. Why would you appear without an appeal? If I ask that question, we don't have an answer. The issue is that we are setting aside the acquittal. Can it be done in a cavalier manner? Can you show us any authority where just because the order is illegal,
The acquittal also goes
acquittal goes without implementing, without an appeal against them?
without appeal against it. Let me try to find out.
Lordship will fix the matter in the first week of April.
We'll take it up at 2 o'clock.
Right.
Just try to find out because the postponing does not solve the issue.
Yes.
It merely is one more adjournment, nothing more. Because if we can successfully, because we are sure that we will not find a judgment where order of acquittal was set aside on technical ground without including them as parties, without there being appeal against acquittal. Because otherwise there would not be a requirement of law to file appeal against acquittal. Anybody can come and say that a collateral challenge, because you see, This is not, this can't be said to be a fraud, because Supreme Court says that if there is a question of fraud, that fraud can be visited even in collateral proceedings. But the judgment of the court can be said to be fraud. No. And even when there is a judgment, on civil side, we understand orders vitiated by fraud. But on criminal side, an acquittal to be set aside without an appeal being registered, you have serious doubts that there can be such judgment.
I think in the Nathilal also where it is remanded because of in the Nathilal judgment, where it is remanded because of this composite judgment.
Was it because without impeding them?
There, I don't think so. There were any acquitted people, but I'll see. If there were, there also the judgment was set aside. After that, it was remanded. But
Judgment has to be set aside.
But
That's what you're saying.
in that case, perhaps acquitted people were not there. I'll see during this recess.
This is the judgment.
That is Nathilal, which is reported here. This is 90 supplementary SSC 145.
Nathilal. It's this one.
Okay.
1990 supplement SSC 145. I think it's 1990 supplement 1 SCC. It's page 3, it is incorrect. No, before that, page 3. No, that citation is there.
He's discussing the case,
Yeah.
yes, I'm just saying.
This is Nathilal, but this would be 1991 SCC, supplementary 1 SCC.
One has not been mentioned. I'm just trying to see what was the case discussed.
This is-
So the procedure has been discussed, here, how it is to be done.
Only it says, I think that procedure, so
There is a-
acquittal and
So that's the different, but it is not mentioned.
We'll take some time and then. In the limited time we had, we could not found, we did not find anything which empowers the court to set aside the order of acquittal without them being implemented as parties. So we proceed with the implement, sorry, so to registration of an appeal. And then issue notice, then what would happen is that if the notice is served and they don't appear, still the court has power and jurisdiction to pass orders. And nobody can then accuse us of violating the principles of procedure which is prescribed.
I think suo motu appeal will not be revision. Lordship will have to again do it through.
Appeal against acquittal,
A revision against acquittal. I think suo motu power in the appeal is not there.
right?
Revision, Lordship can do it.
In division, we can't set aside as what you call a acquittal. Can we do it? It's only appeal against acquittal.
Yes.
So much power we'll have. Power of the High Court, you see, let us see, today there's no complaint. And a palpably illegal order has been passed by the trial court. So what would the High Court do?
Under
So
three
the appeal,
ninety-seven, yes. 397 Lordship has all the power, but superintendent's power over the lower court Lordship has. 397. But I have to again check.
when there is a power for appeal, so much appeal can also be registered. We don't think we'll have, will be, will not be having power to do that. Which is 78.
Your lordship, if I may point one.
We are in a particular thought process, just you're saying something.
That understanding, I believe the revision will not lie here.
Madam, your court.
Sorry, I believe the revision will not lie here, lordship. It has to be a appeal against equitable. Because if we see 401, lordship, 401.
No, we have two authorities of the Supreme Court, which says that 297 can be exercised where illegal exercise of where jurisdictional error has been kept, or if there is a perversity. But this court has already held that the improper uh, uh, trial was conducted because of the fact that instead of trial in two cases, one case was tried and the judgment in the other case was passed. So now we have one judgment which is case of Amit Kapoor of Supreme Court reported in 2012 9 SCC 460. This says that where there is an illegality which has occurred in the order, revision can be invoked. Now we are essentially not against acquittal. The question is that the procedure of trial was wrong. And it incidentally touches on the order of acquittal. First is that the impropriety in the trial itself. That gives rise to the acquittal. So we are in the first part. Correct. There's another authority of the Supreme Court concurring with the 2012 judgment. This is State of Rajasthan versus Fateh Karan Medhu. So therefore, that power is there. So we exercise revision read with appeal.
401 provides that lordship will have all the powers of a court of appeal. 401. So
We
there
take
will be
it.
no problem as such.
Take it. Just write your names in the slip with regard to the two appeal, sorry, the appeal, your position as counsel. That's so and so, slip the next para.
I mean, will there be two sumoto cases or one, lordship?
It will be one,
Be one.
only in respect of the other cases where there is an order of acquittal, 347.
Because in the earlier case also, there are acquitted persons who have already appeared, but they have also been acquitted.
So that can be covered because
judgment note down করলাম এটা কত দিয়ে করলাম
Just tell us one thing. This, there's two cases, criminal appeal 82 and 2018. Correct. The acquittal in connection with this acquittal in sessions case number 131 of 2014. That, in that case, the trial court had recorded the evidence and then ordered acquittal. It is only in this 347 that the evidence was not recorded, right?
The evidence was recorded, but some of the evidence of the other case was taken into consideration while passing this chapter.
So that has happened in 347.
In both the cases, evidence was recorded.
No. This error of appreciating the evidence of another case happened in 347. So in fact, against the acquittal recorded in 131, the challenge is still not made, and therefore, otherwise also when we remand the matter, their acquittal has to remain.
If the judgment is set aside,
No, you see, there are two parts of a judgment, convicting one and acquitting one. Now, which part of the judgment is in appeal? It is only against the conviction. There's an appeal. So there, the acquittal has not been challenged, number one. Number two, you say that two sets of evidence was recorded in 131 as well as 347. It is in the process, it's in the proceedings of 347 that the evidence of 131 was relied. Or is it vice versa?
actually in both the cases, both were relied actually. The differentiation is hard to make. now.
There's no differentiation. Okay, commonly decided. Not one after the other, that's. Okay. This court by order dated 18/9/2023 this court had elaborately discussed the patent error which had crept in the common judgment and order dated 16/2/2018 passed by the learned Sessions Judge Barpeta in Sessions case number 131 of 2014 and Sessions case number 347 of 2015. Full stop. we therefore, comma, there is no necessity of replication of the contents of the order dated 18/9/2023. Sorry, 15/6/2023. Full stop. Next para, it was suffice to mention that we said two sessions cases were tried together, but a common judgment was delivered. But in the process, reliance was placed in the evidence led in both the cases. And this court had arrived at a conclusion that the evidence recorded in the cross case cannot be looked into, and nor can the judge be influenced by whatever is argued in the cross case, and that each case must be decided on the basis of the evidence which has been placed on record in that particular case. Therefore, comma, this court had expressed an opinion that the matter has to be remanded back to the learned trial court for disposing of the two cross cases by two separate judgments. After recording separate evidence of the common witnesses and not considering the evidence recorded in one case for adjudicating the issue in the other case. Next paragraph. This court had also noticed that the accused persons who were acquitted in Sessions case number 347 of 2015 have not been made a party in the present appeals. Next paragraph. Although not although, you say, it is observed that in connection with Sessions case number 131 of 2014, comma, order of acquittal was passed in respect of Ali Bhuyan, ALI, BHUYAN, alias Alim, ALIM, BHUYAN, within bracket, accused number 3, comma, Shah Jahan, SAHJAHAN, Bhuyan, BHUYAN, within bracket, respondent, accused number 8, comma, Nurul Bhuyan, NURUL, BHUYAN, within bracket, accused number 9, comma, Anisul Rahman, ANISUR, Rahman, RAHMAN, within bracket, accused number 11, and Halim, HALIM, BHUYN, within bracket, accused number 13. Full stop. Pursuant to notice issued by the court on the 5 acquitted persons in Sessions case number 131 of 2014, comma, the Miss, your name? Miss F. Hussain. Learned Council has entered appearance. Oh, you are there. You are there. Your name? Mr. A. Hawk. I could, is present. Yes, what do you have to say? No objection, okay. To stop. Upon instructions, comma, the learned counsel for the said acquitted accused numbers 3, 8, 9, 11, and 13 has no objection to the remand of the matters back to the learned trial court for a fresh hearing and decision. Next para. Insofar as all the acquitted accused in Sessions case number 347 of 2015 is concerned, their names are Abu Bakr Siddiq, ABU, next word, BAKKAR, Siddiq, SIDIQUE, comma, Mubarak Ali, MOBARAK, Ali, comma number 3, Taijuddin, TAIJUDDIN, and Bilal, BILAT, Ali, upon whom notices were issued, comma, those served have not appeared. Full stop. Next para, as there is likelihood of prejudice being caused to them on demanding the matter without hearing them, as it would amount to, no, because for the said purpose, the court is required to set aside the order of acquittal, comma, the court is of the considered opinion that to overcome the situation where we have recorded a finding to the effect that the common judgment and order impugned in these appeals is not sustainable, as there was a procedural impropriety which vitiates the judgment and renders it void ab initio, comma. The only way we perceive to be appropriate is to exercise our power of vested in this quote under our section P97 and 401 CRPC, read with section 378 CRPC by directing the registry to register as suo motu revision against the order of, against the judgment and order dated 16/2/2018. Insofar as sessions case number 347 of 2015 is concerned, by which all the four accused named herein before were acquitted. Full stop. Next paragraph. As the certificate copy of the common judgment is already available in the record of criminal appeal number 82 of 2018, as well as in the record of criminal appeal number 85 of 2018, we exempt enclosing of the certificate copy of the judgment in the suo motu revision. Full stop. The photocopy of the said common judgment and the copy of order of this court dated 15/6/2023 passed in common in both the appeals would suffice for the registration of the suo motu revision. Full stop. The said suo motu revision upon its registration shall be laid before this court. For passing appropriate orders. List on. We give it after 2 weeks. We give it after 2 weeks. The matter after 2 weeks. Along with this, two connected, along with this, records with this two appeals.
Public.
See, for now.
Three.
Yeah.
My service report is.
None appears on call for the appellant. Mr. Bhava. Ms. Andas Leonard, APP has produced a copy of the report dated 7/2/2024, sent by the Superintendent of District Jail, Borpeta, pursuant to order dated 19/2/2024. No, not. No. Pursuant to order dated 18/12/2023. Next, by the present status of the health of the appellant is as under. This yellow flag, huh? Yes. Under such circumstances, the Superintendent of District Jail, Borpeta, shall continue to provide medical medication as may be prescribed by the concerned doctors. This one. Next paragraph. As the paper book is otherwise ready, list the matter for hearing in the week commencing 29/4/2024. The before that you write this, this report is written on record.
Eventually attempt to assist you. Advocate blog আছে এরিয়াতে প্রেজেন্ট আছে তেওঁলোকে মানে adjournment লয়
Just is a single bench matter. I am told that therefore adjournment will be made. So you'll have to wait for some time. We'll close this till we rise. You'll have to wait for some time. But then we are adjusting our time for the bench. So we'll extend some time here. We were supposed to rise early. Just wait for some time, come at 3:30.
Okay.
time being item 4.
Yes, item 4.
I have the information, Lordship, that IO has taken steps, Lordship, for service, Lordship. But we have not received the report.
Take it up next Monday.
Next one.
Okay, both sides are represented. Ms. Andas Lalan, APP has submitted that she has received telephonic instructions that the concerned uh, police official, police personnel from Golaghat Police Station have taken steps for service of notice on the respondent number 2. So she awaits further instructions. Most of accordingly, matters are adjourned today. This on, make it next Monday is. Next Monday will be
Day holiday.
holiday. Make it 27th to 7th.
4.
27th.
3.
3.
Time being item 7.
Lordship, 1 week time maybe. given lordship.
Same service report,
Lordship.
same order. This is from which police station?
From Pragjyotishpur, Lordship.
Officer in charge, Pragjyotishpur Police Station. Instead of earlier police station. Pragjyotishpur, PRAG. JYOTISHPUR.
Item 16 to 18.
It has to, no?
That is enough. While in item number 16, so that sentence reference case, and I'm led by Mr. A.M. Bora. And item number 18, it's a similar criminal jail appeal in which the same accused person was convicted of life imprisonment. So, my lord, perhaps this criminal appeal, on the basis of the confession made by the accused person here, he was sentenced to death. That sentence was given to him. So, if this criminal appeal is heard by your lordship at the earliest point of time, then maybe some this
That is what we propose because death sentence is
Yes,
will be taken up in the last.
yes.
First, the regular appeals will be taken up and then followed by death reference.
Yes. So, my lord, item number 18 must have been heard first. Because
Yes,
we have-
yes. Since they are tagged together, there is no difference with that.
my friend,
Lordship can take it up on the hearing day, sir, Ramzan month.
No,
is
for this
very-
bench, every day is a hearing day.
No, if it starts in the morning, it should be better then. Let it be started in the morning, now it's almost 3. Otherwise the flow will stop.
Then we propose that this matter be taken up after 2 weeks. Uh, The intermittent holidays are there. And we are already overburdened with that NIA appeal. It will give you some satisfaction to come inside and look at the volume of evidence which has come out.
In that case, perhaps the hearing is over, Lordship is writing.
Hearing is over now. We got the original exhibits. I think you should come inside and inspect it and then go.
You can understand from here.
That
a
is the
big
volume
job.
of, huh?
It's a big job.
It's the volume of evidence.
And another debt reference is also pending for your Lordship's dictation.
We said that we wanted to go to gym first. You remember? Wanted to go to the gym first before starting adjudication of that, dictating our judgment. We said that, you remember?
I was not there perhaps.
You were sitting, we were sitting with, by the side when the commissioner was arguing. I said that perhaps we'll need to go to gym. And we are more than right. It's a big trunk load of evidence. After 2 weeks, let me complete that.
Finished.
All sides are represented. Mr. A. Dharlanan, Legal Aid Council, Amicus Curie, has submitted that he would that the criminal appeals be heard before hearing of the death sentence reference. Full stop. The said procedure is not objected to by Ms. S. Jahan and APP. Full stop. Next, it appears that this matter is likely to take some time. Full stop. In view of intermittent holidays from 23rd March, comma. Let this matter be listed for hearing in the week commencing 1/4/2024.
Item 19.
Yes.
But the case 33, annexure 5 order is under challenge in this petition. The case 33 order has been issued by the respondent municipal corporation requiring the private educational institutions in the city to register for trade license and requiring them to pay a trade license fee. The order, your lordship, will find at page 33, that is dated 19th of February 2018.
Yes.
I am permitted to read the order. As approved by the General Council of the Guwahati Municipal Corporation in its meeting held on 6/7/2017, the trade license fee for private educational institute within GMC area are refixed as per rate mentioned below. in terms and conditions as specified. Below 20 numbers of student license fee per year will be 1,750. Above 20 to 100 number students, 8,650, and above 100 to 200 numbers of students, 17,300. Subsequently, rupees 8,650 increase in every 100 numbers of students. So this is the order passed, and in pursuance of this order, the demand has been raised to the private institutes under the association of the petitioner. And the basic grievance is that.
So why not? Because you compel people to purchase uniform from a particular place. You compel students to purchase books from a particular place.
Why not books, that there has to be, because of the fact that the particular syllabus.
No, that's okay.
Is
But you
what-
see, we could have purchased the books from any school, any bookshop. But you are restricted,
that
you are
may not-
restricting the, what you call the scope of those parents.
So that may not.
They have a
be-
free choice.
That may not be common for all the schools that are under this.
Most of them,
That may not be common for all. The basic question is that whether the activity of imparting education through educational institutions comes under the concept of trade. It is only then the question of granting or applying for trade license will arise. Now, the notice that has been issued to the petitioners, members of the petitioner association, these have been issued under section 180 of the Municipal Corporation Act. Now, if I can place the section 180 to your lordships, Lord. Section 180 says. Every person who exercises or carries in the city, either by himself or by an agent or representative, any of the professions, trades or callings indicated in the fourth schedule. It is only in case of either of the three eventualities that there would arise a requirement of applying for a trade license. Now, the three eventualities are professions, trades, and callings.
yes.
Now, trade has not been defined in the Act. What would constitute trade? That has not been defined. In the definition clause. In the
You see,
definition clause,
you see, sometime back, not many days back, we read a judgment regarding trademark in respect of Mayo School.
Ajmer.
So, Ajmer. So that school had applied for what you call proceedings of infringement of trademark, like Mayo Hospital, Mayo something. They had applied, and the question was that they were using a trademark, a particular trademark, Mayo, MAYO, Mayo School or Mayo College, I forgot. So therefore, when it comes to protection of the trade name of a school, then the word trade is again inherent in that, in the scope of trademark. Now let us say a school, let us say X school. So X becomes its trademark. Y school, Y becomes a trademark for it. And therefore infringement is alleged. Now the question is, under the definition of the trade which you have,
no,
the
Act
license, the trade license which you have read. So it merely says trade.
no, it
No.
doesn't, yes, it says trade, but what would constitute trade is not defined.
I understand. That's why we are saying. Now you say When it comes to technical jobs, like say water supply or in Indian Oil Corporation, they have, or in the army, they have a calling which is called tradesman.
Yes.
So therefore, there can be what you call hair cutter. There may be a person who's plumber. So they are all within the definition of tradesman. Now, trade is merely a name given to for a particular activity.
It's generic in sense.
Correct. You have used the right word.
It's generic in sense. Yes, I can understand that, my lord. It can be generic in sense, but the question is whether the kind of activity that these tools are undertaking, per se, whether it can be brought within the definition of trade. Because yeah, as the dictionary meaning goes, my lord, trade involves an element of profit making. And more so, regardless of whether or not it's a profit making activity or not, whether in the within the four corners of the act as it stands today, it can be ascertained, it can be assessed that the activity carried out by the members of the petitioner association are trade per se. That is the first question. And the second question will necessarily arise is, my lord, whether the activity of imparting education itself can be regarded as a trade. Because the act, the three eventualities are here: profession, calling, and trade. Certainly, my lord, calling is again a generic kind of a term which is not defined in the act. And the professions are again are connoted, the professions are again a particular word, my lord, which does not apply, does not get attracted to the activity, kind of activity that the petitioner, members of the petitioner association has or has been undertaking.
Yes.
So therefore, my lord, your lordship will kindly have the Municipal Corporation Act 1971. Our specific case is this, my lord, that prior to coming of the present form of the act, the amendments were carried out many times in the Principal Act of 1969. Those were done in the years 1994, 2003, 2012, 2019, and 2020. But in neither of these acts, my lord, the kind of activity which the members of the petitioner association has been undertaking was subjected to any requirement of obtaining trade license. Now, this for the first time has been inserted in the act now, fourth schedule now. But surprisingly, how it has come, whether it has come by way of amendment or by way of a gazette notification, executive instruction, nothing is understandable. At least the response of the respondents, the affidavit filed by the respondents also do not throw any light to this aspect of the matter. If your lordship will kindly have the Municipal Corporation Act 1971 and particularly Annexure 1 to the fourth schedule.
Municipal Corporation Act.
I can lend this book without if the lordship permits. Yes, page 184. Page 184 and 194.
184, fourth schedule.
Fourth schedule. And 194 will be the annexure 1.
This is, no, yes, annexure 1, well, we are showing this for what?
Annexure 1 is the only part of that particular schedule, my lord, in which, my lord, the requirement of obtaining trade license by private institutes, private education has been incorporated. But this was not there in any of the previous versions of the act, at least till the year 2020. Now, how this came to be incorporated here, whether it is by way of a executive instruction or amendment of the act, nothing is disclosed. Your lordship has seen, your lordship will kindly, under annexure 1, your lordship will kindly see the entry 11. Private schools above 300 numbers of students.
Yes,
Private schools above 300 numbers of students. Well, these came to be incorporated only by means of this annexure 1. And what is the source of this annexure 1? It is shrouded in mystery.
okay,
But this was not there previously. And there is a specific stand taken in the writ petition. Your lordship will kindly see paragraph.
Whether this annexure 1 was there previously and it's only 11 that has been mentioned.
Yes, in 11, the school. Yes.
But this whole annexure 1, the other subjects, was it there, was it there before the amendment? Or the whole annexure 1 is something that?
Annexure 1 is completely new to the.
The whole annexure.
Whole annexure 1 is completely new to the new addition to the fourth schedule. Now, it is not certain whether it has been brought by way of an amendment or by way of an executive instruction or how. That is not understood. Our specific case is at page 8, paragraph 9. Your lordship will kindly have paragraph 9 at page 8 of the writ petition. I know that's got it, right? Eight. Well, may I read it?
Yes.
That the petitioner association begs to state that immediately thereafter they, through their engaged counsel, searched in the Guwahati Municipal Corporation Act for the provision declaring establishment of private schools, educational institutes as trade. The original act of 1969, named as Guwahati Municipal Corporation Act 1971, does not have any provision saying private schools, educational institutes as trade. For there was no any annexure 1 to the 4th schedule. Even the Guwahati Municipal Corporation Acts for the year 94, 2003, 2012, 2019, and 2020 did not make any amendment incorporating private schools, educational institutes as trade. But surprisingly, the new publications of the Guwahati Municipal Corporation Act provides for an annexure 1 to the 4th schedule, with adding trades to be included in class 1 category, which includes at serial number 11 private schools above 300 number of students. Now, as against this, my lord, kindly see the response that the respondents have given at paragraph 8 of their affidavit in opposition. Their affidavit in opposition is dated 19th of November 2020.
There's no response.
Exponent denies the correctness of the same. This is one aspect of the matter. The second aspect of the matter is that, my lord, তো বাদ গেছে পরে পরে বাদ গেছে এক্সিটের উপরে কেস হয়েছে কিন্তু পরে খুঁজে দেখো আমি খেয়াল করি নাই এখন দেখলাম পরে কেস হয়েছে
This is.
Now, my lord, assuming for a moment that they have done it validly, this incorporation of annexure 1 in the fourth schedule has been done validly, assuming for a moment. The question still remains is whether by the description, by the connotation of the words trade, calling or profession, it can be classified. The activity undertaken by the petitioners, members of the petitioner association can be identified as one of the same. That still remains to be examined and answered.
We'll continue day after tomorrow because we'll have to break for single bench.
In that case, can it be
Day after tomorrow,
Thursday? My lord. Tomorrow, actually, I am going out of station. I'll come back on Wednesday night,
Thursday,
Thursday.
Thursday. Okay. Due to positive time matter could not be heard today, list on Thursday. Thursdays, 21,
21.
3/20/20.
আর ওটা নামাতে পারবে, আর ওটা নামাতে বেরিয়ে যাবে। সিঙ্গল বেঞ্চ ডিভিশন এটা আছে।
No, that has to be adjourned. Item 20. Item 20 of single bench will have to be adjourned.
It may be fixed, my lord.
Four weeks দিলে হবো, list of the 4 weeks.
এইটো নালাগে
কওক স্যার, কওক।
মই কৈ আছো
After 2 weeks হইলো।
পার্টি জি হাল্লা কৰি আছে
হলে
আহি থাকক না লিষ্টত আহি থাকক হয় হ'ব নহ'লে
কওক।
my lord, admitter may be fixed in this week.
Okay, Wednesday.
Yes, yes.
Matter could not heard, and I have seen on website, my lord. This matter likely to be posted on 20th of March. 20 March, Lordship.
Lordship, there's another prayer from our side, Lordship. We are withdrawing our names from the fifth floor.
No, you have to file an application. It can't be done orally.
I have already submitted the application before the registry, Lordship. I have to file here also. I'm not for withdrawing the advocates council's name.
You have filed an application. This application is not listed today.
No, it's not listed. Okay, we'll file it, Lordship.
Okay. Both sides are represented on the prayer made by Land Council for the applicant. List on 3/4/2024
My lord, can it be after Bihu vacation, my lord?
after BU. Okay. List on 22/4/2024. Next, Mr. DJ Kapil, Land Council for the opposite party. Submits that an interrogatory application has been filed.
I have filed an application just also. I'll file an IA. Actually, I have just filed
Any application you file will be an IA.
This is just to the register judicial, Lordship.
Oh, Asha, no. That will not.
I'll file a proper application, Lordship.
No, then not required. Okay.
I'll oblige, Lordship.